If you've ever worked for the government, you know the rule book is thicker than a dictionary. But what happens when the government itself just throws that rule book out the window?
Welcome to the Deep Dive, where we are cutting right to the core of a really high-stakes legal battle. We're talking public employment, due process, and a legal maneuver so aggressive it almost never works.
That's right. Our source material today is the full transcript of a very charged court hearing. It's Frey and others versus City of Eunice, case D506CV 2020-825. And this case features two former police officers standing before a district court judge and, well, demanding something pretty radical.
Right, not just money down the line, but the immediate emergency restoration of their jobs.
Or at least their employment status. Exactly. So our mission today for you, the learner, is to unpack the legal calculus behind this. It's kind of extraordinary action. We need to understand the rigorous four-part tests for what's called emergency injunctive relief governed by Rule 66. And we're going to analyze just how deep the constitutional due process hole gets when a government entity allegedly fires its own employees without following its own rules.
So to set the scene for you, we have two plaintiffs, both former police officers. There's John Frey, who had actually recently demoted himself from chief of police right before this all started. And Sergeant Todd Dimmock. Now, they were fired by the city manager, a woman named Shannon Cummins. The city is being defended by their counsel, Miss Miller, and the whole thing rests in the hands of the judge, Tom Lilly.
And the core conflict here, and this is so important, it's not really about whether the officers actually did what they were accused of. It's about how they were fired. Their lawyer, Mr. Grover, argues that the termination wasn't just unfair, it was legally void, because the city, he claims, failed to comply with state laws, local ordinances, and most crucially, constitutional due process.
So they're asking the court to fix the process right now, not years down the road in some other lawsuit.
Okay, let's unpack the sequence of events. Because when you see how quickly this escalated and just how adversarial it all became, it really helps explain why they skipped the normal routes and went straight for this emergency injunction.
The timeline is a flashpoint. I mean, It is quick and it is contentious. It all kicked off on March 17th, 2025.
Well,
both plaintiffs were summarily placed on administrative leave pending an IA investigation.
An internal affairs investigation. And then what?
The very next day, March 18th, they received target letters.
Okay, so a target letter is the official notice that you yourself are under investigation. And what was the initial focus? What were they looking into?
It was incredibly specific and, frankly, pretty low level. The letter just cited inaccuracies in timekeeping.
So like a timesheet issue.
Exactly. That letter went to 4 officers, 2 of whom were later totally cleared and reinstated. But here's where the tension really spikes. On April 2nd, so about 2 weeks after being put on leave, the plaintiffs submit a formal memo.
And who did they send this memo to?
Directly to the city council and the mayor.
And what was in that memo? I mean, that's a bold move.
It was. It detailed some very serious allegations of improper, maybe even unlawful conduct by the city manager, Shannon Cummins.
Wait, the same person who was investigating them?
The very same person who held their jobs in her hands. So, in effect, the officers were whistleblowing on their own investigator.
Wow, that just changes everything. It goes from a simple internal audit to this outright political and legal grudge match. It's hard to imagine the investigation being impartial after that.
Oh, absolutely not. So the investigation goes on for a few months, and then on June 22nd, the city manager issues predetermination letters. That's the formal notice of intent to fire.
And this is where the first major procedural problem comes up, right?
Right. This is what the Officers' Council calls scope creep. These letters didn't just mention timekeeping anymore.
So let's nail that down. What were they suddenly facing?
For John Frey, the list just exploded.
Yeah.
It went from that one issue, timekeeping, to 6 brand new allegations. Things like taking calls from his house, failure to supervise, and even accusations of dishonesty.
And for Sergeant Dimmock?
He got 4 new issues. They expanded it into failure to supervise and potential outside employment conflicts.
So they were completely blindsided. They go in thinking they need to defend against some time clock errors, and suddenly they've got this avalanche of new claims, including dishonesty, dropped on them just weeks before the final decision.
Exactly. Then on July 17th, they were formally fired by Cummins. And just 6 days later, July 23rd, they filed this application for emergency injunctive relief, Rule 66. It was an immediate, very aggressive counterpunch.
So why this? Why this extraordinary measure? I mean, in employment law, if you feel you were fired illegally, you usually sue for damages, right? You ask for money. Why the demand for reinstatement?
It's all about a concept that's just fundamental to public employment law. The property interest.
A property interest in your job.
Yes. For most of us in the private sector, employment is at will. You can be fired for almost any reason as long as it's not illegal discrimination. But for classified public employees, like these police officers, the law treats their job like actual property.
Like a house or a bank account.
Precisely. And the government can't just take that property away from you.
Okay, so they can take it, but they have to follow a very strict legal process.
Due process, exactly. And if that process is broken, the government has, well, infringed on a constitutional right. So Mr. Grover argued this isn't about the money. He wants the judge to restore the constitutional status quo ante.
The way things were before. And what status are they actually asking for? They're not asking to go back on patrol tomorrow, are they?
No, that would be a huge ask. They're only asking to be reinstated to administrative leave status.
Oh.
With back pay and benefits, pending a proper administrative hearing. So in essence, they're asking the judge to use his equitable power to rewind the clock to the day before the city allegedly started trampling on their rights.
Forcing the city to start the whole disciplinary process over, but correctly this time.
That is the core argument.
That is a critical distinction. It's not about guilt or innocence on the charges. It's about the process. They're asking the court to supervise the local administrative process, basically saying, you forfeit your authority when you ignore your own rules.
That's their whole thesis.
Yeah.
And to prove the city forfeited its authority, the plaintiffs laid out 5 specific procedural violations that they claim make the termination simply void. And this is where the legal weeds start to get really compelling for anyone interested in this stuff.
All right, let's dive into those alleged due process failures. We can start with that scope creep idea we just mentioned.
Okay, so the first one is exactly that. Lack of notice and scope creep. Due process demands that a person knows what they're accused of, in advance, so they can prepare a defense.
But they didn't get that here.
Their argument is no. When the allegations exploded from just timekeeping to dishonesty, without any prior formal notice or any chance to be interrogated on those new points, the defense argues it just violates the whole spirit of a fair proceeding.
Okay. But the second violation seems to go even deeper, right? Into the city's own internal structure.
It does. Violation 2. Bypassing the chain of command. The City of Eunice Policy Manual, specifically Section 1407, is crystal clear. The department head, in this case, the Chief of Police, Danny Garrett, he has to be the one to authorize and then request the city manager's approval for a dismissal.
And that didn't happen.
Mr. Grover stated, very emphatically, that Chief Garrett was not involved. He didn't authorize the termination. He didn't even go to the predetermination hearing.
Wait, so the city manager just did it unilaterally. She bypassed the entire authority structure that's required by the city's own manual.
That's the claim. And if it's true, that is a severe failure. I mean, if a municipality doesn't follow its own rules on who has the power to fire someone, that firing is highly questionable, regardless of the underlying facts.
And then you have to layer on the political tension from that April 2nd memo, which brings us to the conflicts of interest.
Right. Violation 3, conflicts of interest. City Manager Cummins presided over the predetermination hearing, even though the officers had filed formal complaints against her.
It's hard to claim you're impartial when the person judging the case is the target of complaints from the accused.
It's nearly impossible. And to make it worse, the city council, Tommy Parker, was also there. And Sergeant Dimmock had been involved in Parker's arrest several years prior. It just suggests a pattern of interested parties driving the whole process.
You can just feel the tension in that room. Okay, what about state-level requirements? Did they follow those?
Well, that's violation 4, rights under state law. The plaintiffs argue the city failed to comply with the state's Police Officer Employer-Employee Relations Act.
And what does that act require?
It requires the disclosure of the complainant's identity and the nature of the investigation before any interrogation starts. Mr. Grover asserted the city provided none of this required information.
That's a huge protection for officers, knowing who is accusing you and what the specific charge is before you have to answer questions.
Absolutely. And that brings us to the final one. Violation 5, failure to advise of appeal rights.
So they didn't tell them how to appeal the decision.
The July 17th termination letters that Cummins issued completely omitted any statement of the plaintiff's right to appeal. This is a direct violation of their own Policy Manual 1407. And this last failure really is what pushed them toward the emergency injunction.
Because if the city doesn't tell you how to appeal and that appeal window closes, you've lost your formal remedy entirely. That is a massive injury.
It is. And summing this all up, Mr. Grover cited New Mexico case law, specifically cases like Miller, Foster, and Lopez, which established that when a municipality fails to comply with its own published procedures, the action it takes is a denial of due process and is, quote, simply void.
The principle being that the government has to obey its own laws, or its actions just have no legal force.
Exactly. The argument is that the city's actions were so procedurally contaminated that they never legally terminated the officers in the first place.
But the city, of course, fought back hard against this. What was Ms. Miller's main defense?
Mrs. Miller argues, quite forcefully, that the court should not be wading into local employment disputes using an extraordinary and drastic remedy, like an injunction. She says to get an injunction under Rule 66, the plaintiffs have to prove all four required factors, and she argues they failed on every single one.
Let's start with the most important one for any injunction. Irreparable injury. Why does the city say the harm isn't irreparable?
Because the plaintiffs are asking for back pay and damages. So Mrs. Miller's argument is, since money is recoverable through other legal remedies, the harm is not irreparable. She points directly to the possibility of filing a lawsuit under Section 1983.
And for our learner, what is the 1983 claim?
The Section 1983 civil rights lawsuit is it's the main federal legal route you take when a state or government official violates your constitutional rights. It's the standard remedy for due process violations.
So the city's point is, go file that lawsuit, get your damages later, but don't ask the judge to manage our police department today.
That's the argument. Go use the adequate remedy the law provides.
Which makes a lot of sense strategically.
It does, but Mr. Grover argues that compensation isn't enough. And Mrs. Miller had a counter for that too. She questioned whether a constitutional violation is mandatorily irreparable outside of, say, First Amendment free speech issues. She referenced the 10th Circuit's precedent on this.
The Federal Appeals Court for this area.
Right. She's essentially telling the judge, the federal courts in this region are skeptical that due process violations are automatically irreparable harm. It's a very high bar to clear.
Okay, what about the second factor, the status quo?
The city's argument on that is pretty simple. The status quo is that the officers are terminated. Reinstating them completely alters that situation. An injunction is supposed to preserve what is, to prevent more injury, not to reverse a decision that's already been made.
So they're saying the officers waited too long and termination is now the new reality.
That's their position.
And the public interest argument must be pretty powerful in a public safety context.
It is. The city claimed that forcing them to re-employ individuals who were terminated based on valid concerns, we're talking allegations of time fraud and dishonesty, that poses a real risk to the public.
Yeah.
And it endangers taxpayer dollars.
So the city manager made a call to fire them for cause, and the court shouldn't second-guess that, at least not temporarily.
Exactly.
And finally, what about the likelihood of success on the merits?
The city's position here is procedural. They argue that since the plaintiffs haven't filed an underlying claim, like that Section 1983 suit we mentioned, or a breach of contract claim, the court can't properly analyze their likelihood of success. It makes the whole injunction request feel, in their view, premature, foundationless.
Okay, let's turn to Judge Lilly. Reading the transcript, he sounds, genuinely mystified. He's very conflicted about what he's supposed to do here. What is the fundamental struggle he's having with this case?
His core struggle is all about authority, or as he puts it, the four corners of his power. He is openly questioning whether he even has the legal power to do two things. One, issue an order that gives someone their job back, even temporarily. And two, issue an injunction by itself without an underlying lawsuit filed alongside it.
He seems really wary of overstepping his role as a judge.
He is. He even says he's seen judges issue temporary restraining orders without other claims. But issuing full injunctive relief, in and of itself, just based on this procedural application, it makes him really uncomfortable. He even references this internal maxim: be aware of those who ask you to exercise authority you don't really have.
He's worried he's being led down a path he can't legally go down.
Pretty much. He feels it might be premature.
But Mr. Grover, the plaintiff's counsel, really pushed back on that hesitancy, didn't he? He argues that the constitutional violation is the irreparable injury, no matter if they can get money later.
He does. Grover emphasizes that, damages alone don't fix the loss of professional standing. The stigma of being fired for dishonesty, the loss of their status as police officers. He frames the injunction as necessary to impose, quote, consequences upon the government factor for its failures.
So hit them now. Make them fix it now.
Exactly. He argues that forcing the city to fix the process right now is better than letting them drag out a 1983 lawsuit for 3 years, only for the officers to maybe get a check, but without their reputations ever being fully cleared.
And that ties directly back to why they took this massive risk in the first place. By filing this injunction so quickly, they might have let the clock run out on their administrative appeal rights with the city. They banked everything on the judge stepping in immediately.
It was a calculated risk, a desperate one, you could say. They filed the injunction because they believed the city's refusal to follow due process, plus the failure to tell them about their appeal rights, had already tainted or even destroyed their administrative remedy.
So they're telling the court, if we wait for a normal lawsuit, the damage to our careers is already done, and the city gets away with these gross procedural violations.
That's it in a nutshell.
This deep dive really reveals the precarious balancing act in public employment law. For you, the learner, the key takeaway is that when you're dealing with a government entity, due process is the shield. The absence of procedural compliance, bypassing the chief, changing the rules mid-game, ignoring state law, it can legally void even strong substantive allegations of wrongdoing, like time fraud. It means the form of the termination can sometimes matter more than the substance of the facts.
And this raises a really important critical thought for you to mull over as Judge Lilly takes this very complex matter under advisement. If the court agrees with the plaintiffs and voids the termination because the city violated its own procedures, those original serious allegations of misconduct, the claims of time fraud and failure to supervise against Frey and Dimmock, they were never legally adjudicated. They're never proven true. The city just has to start over. So this makes us ask the question, does the absolute necessity of fixing the process mean we sometimes must temporarily forfeit the ability to achieve justice or accountability regarding the underlying facts?
That is the ultimate tension in the law, isn't it? Where the means must justify the ends. Thanks for diving deep with us into the complex world of Rule 66 and police employment. We hope this gave you a clearer understanding of how the law fights back against procedural overreach.